First off, I'd like to acknowledge my respect for and share my deepest gratitude to the Ktunaxa peoples on whose homeland I'm honored to live and work. Today's presentation will be about the Provincial Court Family Rules. These are new rules that came into place last year, and there are lots of cool and interesting changes. And so I'm hoping with today's presentation to go through and highlight some of the major changes and share with you some practical tips in terms of preparing the forms and assisting clients that are seeking to make applications or responding to applications. So in terms of a brief agenda, we have, slightly less than 2 hours. And we're going to go through the new purpose and objective of the rules, talk briefly about the registry requirements. Then we're going to launch into the big topics, applying for orders and making applications generally. Then we're going to talk about 3 new processes that are in place, which are the family management conferences, the family settlement conferences, and trial preparation conferences. Now let's go through briefly the purpose and objective of the rules. Now, having come into force in May of last year, these new rules really aim to encourage parties to resolve case by agreement. It allows parties to work together better. There are more steps that are clearer in order to facilitate, parties coming to decisions by consensus. It aims to really help parties reach timely decisions that are just. It definitely acknowledges the impact of conflict, and especially, high conflict and extended conflicts on children and on their families. And in doing that, we're hoping to minimize that conflict, promote cooperation as much as possible, and create, processes for resolution that are efficient and consistent with the complexities of each case. So the simpler cases we're hoping will exit the system, as quickly as possible. And that is to kind of just minimize conflict and encourage parties to be able to co-parent together. Now, we look at what are family law matters because these applications are about family law matters. Now, family law matters in provincial court, we're likely looking at guardianship, parental responsibilities, where the children reside, parenting time, meaning, what kind of time each parent spends with the children, and contact, where the parties are not guardians. We can also talk about support issues generally, child support, spousal support, as well as some types of protection orders, and also conduct orders. What provincial court, of course, does not deal with and is in the exclusive jurisdiction of the Supreme Court are matters concerning divorce or matters concerning the division of assets, family debts, family property. That's all going to be in British Columbia's Supreme Court. So if you're in provincial court, you're likely working with support issues, protection issues, or things dealing just with children. Now, the new Rule 7 covers which registry you are supposed to file your documents. So previously, this part is a little bit unclear, but the new rules certainly assist in parties deciding, and not so much deciding, but choosing the registry to file in. So first of all, if there is already an existing case dealing with the same 2 people, or it can be more than one party, sometimes we're dealing with step-parents as well, or grandparents. So if we're talking about the same parties, there's already an existing case. The registry is clearly going to be where that current existing case is located. But if you're filing a totally new application and there's no existing case with the same parties, the registry then to be chosen is if the matter involves children and child-related issues, it is the residence where the children live most of the time. So, if most of the children reside in Cranbrook, then the Cranbrook registry has to be the one where you file your initiating application. if there are no child-related issues, so now we're just talking about strict protection orders or strict orders concerning spousal support, we are now talking about the residence of the person who first files the document. So if, that one person who's seeking spousal support or protection order resides in Kamloops, then they must file in the Kamloops registry. So there are also designated registries pursuant to these new rules. This means that at those specific designated registries, there's going to be some requirement to complete a needs assessment, a parenting education program, or some type of consensual dispute resolution. It could be with a family justice counselor or another means if you're located at those specific designated registries. Now, I understand some of you may have even taken a course earlier on this month about those designated registries. Surrey and Victoria, for example, are part of the Early Resolution Registry. Then Kelowna, Nanaimo, and Robson Square in Vancouver are part of the Family Justice Registry. There are also other registries around the province from Abbotsford, Campbell River, Chilliwack, Courtenay, Kamloops, New West, North Van, Penticton, Port Coquitlam, Prince George, Richmond, and Vernon. They are part of the Parenting Education Program Registry. And that leaves all other registries that we haven't just spoken about being part of the remaining registries with no additional requirements. This means if you're in, say, Cranbrook or Fernie, you will not need to undertake any other steps, and that you would just file the application, and that would be the first step you take. There's still the availability, of course, to take the online parenting after separation course, which I always recommend parents who are going through separation do. It's fully online, and it's very helpful as a resource for parents to learn about how to co-parent after a separation. That is still available online, but there is no specific requirement to undertake additional steps, although parties will still need to kind of complete that online education program and get a certificate of completion. So the biggest change perhaps are these new application forms. And I have to say, when I first kind of laid eyes upon them in April, even, as a family practitioner who's, done this for a decade, I was shocked at the size of the forms. If some of you will remember, back in the day, an application form, I think, was like 2 to 3 pages. A notice of motion, I think, was a single-page document. There are, 6 check boxes after where you fill in your, contact information, and you check those off and away you go. The new form certainly very much deviates from that. And I think, many of you are in support worker roles. The biggest hurdle, and I'm sure many of you have looked at the new forms and have had to work through them in the last few months, it's a daunting task. And I think, where my goal is today in assisting kind of your learning in these new forms is hopefully getting to a place where we all feel comfortable about the new forms, comfortable working with clients with these new forms, and just to make the process much less daunting. Because when you pick up a document that's like 55 pages long with like thousands of words inside, it can be extremely overwhelming. So without further ado, let's talk about these new forms. Now, of course, every single form is new. Some of them do look like their predecessors, the simple consent order forms, for example. But all these new forms have something special about them in that they have now all gone into a first-person question and answer format. This is great because it really allows people to kind of provide their own narratives in a meaningful way. I've also noticed as part of the forms, they have extensive explanations on the left side of the form, on the back page of the form, that explains, what they're looking for. And I've found lots of helpful pointers in there. And I'm sure, as someone assisting another person in filling out those forms, having that, point by point guidance on the flip side of the form is very helpful. Now, especially with the initiating document, which is the application about a family law matter, there are tons of schedules. And again, initially, that could be a very daunting experience going through that form the first time, but you only need to fill out the schedules that apply. Now, let's talk briefly about the sequence of who files which forms to get a family law matter started in provincial court. The initiating party will file the application form, which is called Form 3. Now, all of these forms are helpfully located in the provincial court website as a fillable PDF format. From my experience, for those of you who might have access to a program called DivorceMate, they have like a version of the form that has clicking schedules. So that's very helpful as well for those of you who have access to that program. Otherwise, I've had other workarounds where, say, you need more space, you can attach just blank pages or typed up notes to the PDF application form if the fillable boxes are like too tiny and there's not enough space. Now, once the first party goes and files the application, the responding party will need to file their reply and also their counter application, which is in Form 6. The first party then will get a copy of that, and they will get an opportunity to reply to the application with the counter. And then from there, the next step is usually everybody attends a family management conference, which they get a date through the registry. Now, talking about the schedules, this is an excerpt of the forms. And throughout this presentation, I've put in various excerpts to the forms just to highlight some things that you'd be looking at. Now, Form 3 starts by, I'm applying for a court order about the following things. As you can see, you can choose parenting arrangements, child support, contact with a child, guardianship of a child, spousal support. These are the main schedules that are available. And depending on what you're looking for, say a totally new parenting arrangement order, and so you can see the new, that is a Schedule 1, so you need to complete Schedule 1. If there's already an existing order or agreement, then you complete Schedule 2, and so forth. So you can see there are 10 separate schedules, which explains why the form as a whole is like 50+ page long. So you only need to fill out the schedules that are relevant, and you can kind of discard all the other pages. Now, under the parenting time section, and I go into I'll be going into great depth about this because there's a lot of nuance to it and some pitfalls that you could encounter. So let's quickly go over what the form asks, and then we'll go into some depth as to what kind of information you might be wanting to get in here. So the form wants to know about parenting time. During parenting time, a guardian has the parental responsibility of making day-to-day decisions affecting the child and having day-to-day care, control, and supervisions of a child. Complete Section 3 below only if you're applying for an order about parenting time. Obviously, you can leave this section blank if there are no kids involved. So paragraph 3, I'm applying for an order about the allocation of parenting time as follows. I'm asking for the children to spend time with me as follows. I'm willing to have the following conditions placed on my parenting time with the children. And I'm asking for children to spend time with the other guardian as follows. Now, taking a step back from this form, going back to, pre-2021, the form that we're in, it really did not go into this level of detail. And one of the pros and cons of this new type of form is, for me, the pros are that you can be really clear about what you're looking for. You it also makes it much easier for the person who's answering your application to figure out exactly what you're looking for so they can answer properly. It allows the court to tell straight off the bat kind of what your position is. But the cons are kind of the flip side of that. It makes your client commit to a position pretty early on in the game. And from either a support worker or a lawyer perspective, when we work with a client, you know, it's so common that you're getting them at a very vulnerable time. They might have just separated. Lots of things might be in a state of flux. The living arrangements might not be certain. They might be really upset. And, you know, as we all know, you don't have the clearest head, and you might not be the most rational about kind of what you want and what is in the best interest of the children when you're like super upset. And it also makes this a really overwhelming task to commit, you know, straight off the bat as to really have a full plan. And for so many of my clients, like, they don't have it all figured out when they're like a week from, you know, breaking up with their spouse. They don't necessarily know what they want, and to essentially write a mini essay about, you know, what they're willing to do, what they're hoping to accomplish. You're really walking the fine line between kind of over committing straight off the bat and, you know, maybe being too restrictive and too harsh. And then you become very positional. And I think, but what I mean by that is you also don't want to be unreasonable in your initial ask, because I'll say this is kind of your initial ask of the court and of the other party, right? This is like what you're saying, you know, you're hoping to achieve and you think it's in the best interest of children. And sometimes because the beginning of a separation, you know, everybody is upset. You also run the risk of putting something in there that you could later on regret. Obviously, you can, you know, amend the form if you've made an error or if circumstances have really changed to make you, you know, deviate from your position. But this is something that the other party will get and they'll read, and the judge will get and he or she will read. So, you know, they're really delicate things that you'd have to explore when you sit down with a client and you help them fill out this portion to really think about what are their underlying interests, you know, what would best serve those interests, and to not get too positional. Like, you know, sometimes people have a false understanding of what, you know, I want to be the primary parent. I want all the responsibilities, you know, and if you really work around that and you explore, well, you know, if Timmy broke his leg, like, you would still tell the other parent, right? You know, which means you do, you know, if Timmy requires surgery, you would talk about that type of decision with the other parent, right? To really, you know, get to the bottom of, you know, are they really looking to solely have all parental responsibilities? Are they just saying that, you know, they would like those responsibilities, but they would like to consult with the other parents still about those important decisions? I think those are, and that comes down to perhaps you're going to need to send your client for an initial consultation with legal counsel to really explore those questions and, you know, fully flesh them out. Or if your client have limited means, of course, you can, you know, ask them to go to the Legal Services Society to see if, and call the law line and explore those options. But there's actually a lot more to it with these new application forms that certainly meets the eye. Now, in answering the first question, I'm asking for the children to spend time with me as follows. Here's where your client could put a very fully fleshed out schedule. You know, if that's, it could be as simple as I want them to primarily reside with me. Or if your client was comfortable, you could talk about a particular schedule that works with their work and describe what the work schedule is and how that rotation would look with parenting time. or if it's a shared schedule, what that would look like. If dad or mom works 4 on 4 off, how the children's time are going to be split if it was a rotational. You can even consider what the shift schedules would look like to talk about, when exchanges would be and what time they would be. So you can go into great detail when talking about the conditions to be placed on the parenting time with the children. We could talk about exchanges. We could talk about phone time. If you were really kind of getting into the nitty-gritty of specific things, many people will even put in a full holiday schedule. But that really is getting into like great detail. Now, of course, you might want to get into that amount of detail because if you didn't ask for it, you're not going to get it. So if there's a specific arrangement for the holiday season, say, Hanukkah is very special to your client and they would really, their family, their side of the family are the ones celebrating Hanukkah, you might need to specifically state what your wishes are for the holiday parenting time here so that the other side can make a full reply and answer. If you haven't asked for it, you can't assume that later on the judge will be dealing with those specific topics. So you might also want to talk about holidays, spring break, Halloween, birthdays. There's really a lot that could go into, paragraph 3, other than, the simplest form would be shared parenting time or primary residence and just putting 3 words. But, that is not necessarily what it's going to garner your client the result that they're looking for with the amount of detail they're looking for. If, it was important to them to visit family overseas, once a year, that's something that you're going to have to add into paragraph 3 as your initial ask. If they need to be overseas for like 3 weeks of a year in order to do that. Any questions on this part of the form? Like paragraph 3 is a pretty huge and one of the, not the most dicey aspects of the form, but certainly could be the most instrumental for many clients. So let me know in the chat if you have any questions.
There is one question. Can it be point form? Absolutely.
Yeah, it can be in point form. I've seen lots of people do it in point form. In fact, I think it's helpful if you did it in like numbered paragraphs. If you have a lot of asks, instead of putting a giant paragraph, it allows later on, especially at a hearing, for you to kind of check each of them off, like, okay, regular parenting time is at paragraph, 1. Paragraph 2 is about, spring break, and 3 is about summer holidays. So it also allows a judge to clearly see, and, you can see the boxes are not all that big. So this is where you might say, please see attached Appendix A or, attached to this form, and just have it typed up as like 1, 2, 3, 4, and 5, all your requests about various holidays. They would all go in here. Any conditions to be placed on, parenting time would go in there, and they can all be in numbered paragraphs. Yeah, go ahead. Thank you. Okay, let's look at
I thought you were done answering the question. Sorry if I interrupted you.
Hey, no worries. So let's go to the next part of the form. Has a little box that says, I'm applying for the following orders about parenting arrangements. Now, this is just blank on the form, but this is where you might want to talk about a whole bunch of things, including, are there any communication requirements? It's pretty common for high conflict relationships to have communication requirements. This is where your client might say, yeah, let's limit all communication about the children in writing. You can say, limit all communications in writing by some method, email, text message, some kind of co-parenting app on your phone. You can also specifically request that the parties don't talk at all other than about, say, things about the children. So, this might be the case where one person feels harassed by the other. They don't want to get all those messages about, I want you back, that kind of thing. They want to just limit the communication to things about kids. This is where you would put in those communication requests. Now, exchange and transport is also something to be mentioned. That's not immediately, apparent when you're just looking at, I'm applying for the following other orders. It might not jump out at any of your clients that this is where they're supposed to mention like how the pickups are going to go. If they're in different communities, who's doing the driving? Are they meeting halfway? Are they, sharing gas money? Does the parent starting parenting time always be the one that goes to pick up or drop off? I know a lot of times when you've got a situation where one parent is like, the other side kind of shows up once in a while, but is not always on time, etc., then it's probably important that the other side be the one to come to your house to pick up, because if they're late, you're not waiting for them at the side of the road, you're kind of at your home. So if they don't show, then you just carry on your business for the rest of the day. But the children are not otherwise inconvenienced. So that's something to keep in mind under the exchange and transport, talking about who's driving and who's picking up to start their time. Location of residence is also something that many people will talk about here, especially if they either want to move somewhere or they want to make sure nobody moves anywhere. So there might be a requirement that you could ask for, which is like, nobody move the children's residence, outside of 50 kilometers from Golden, or, not to change the children's schools. Those are the type of other orders that you might want to get into this, the answer to this question. You can also talk about travel outside of province and outside of country. As we know, sometimes it's difficult crossing the border, especially for parents who say don't share the same last name as their children. And so, you probably want some type of order, a court order that says you may travel with the children out of province and out of country. Other parents would be looking for specific clauses that, hey, if the other side does travel outside of the country and outside of the province, I want 7 days notice, or I want, a week's notice. I want exchange of travel letters. I want, ability to call the children while they're away every other day, or I want a full itinerary if anybody ever goes anywhere out of country for, more than a week, that I know where they're staying. I know I get a list of all the hotels and the ways to contact the children while they're away. This is also where you would put in those requests. Again, not immediately apparent on the face of the question, but certainly things to think about. Also, what happens if there are problems with parenting issues? Is someone the tiebreaker? Is there a veto by one parent? Must they go back to meet with their counselor if there are disagreements? And how to make changes to parental responsibilities and parenting time going forward. Like, is it a requirement that everybody must go back to a family justice counselor if there's a disagreement, or to mediation, or to their counselor? So these are things that you could ask for in this segment of the form. Now, as you can probably tell at this point, there's so much more than meets the eye on this application form. Budgeting-wise, it impacts your work and your client in a number of ways. First of all, whereas previously doing an application with a client might have taken you an hour, you can probably tell this is going to take many hours of work, many hours of exploring things, and many hours of just like committing your position in writing and getting it just right. So budgeting wise, it'd be making those appointments with these clients, doing up the form. It's going to, you're going to have to factor into, just how much information and how much detail and depth you'd like to get into the application. The budgeting also goes towards if you're hiring legal counsel to prepare this initiating form for you. From my own personal practice, I can say that it has drastically increased the cost of filing a provincial court application and getting it past the first stage. Papers handed in, waiting for a court date with a judge. Whereas, that might have taken 2 or 3 hours of legal time, meeting with the client, preparing the form. Doing a good job at this form is now going to be like 5 to 10 hours, depending on the level of detail we're getting into the form and, just how much exploration you're doing with your client, which means budgeting for hiring private counsel, or even with working with your legal aid counsel to build a form that, has all of this information. It's going to eat up a lot more of the originating time than was previously, likely going to be the case. Although one can say it just kind of front end loads the process, because these were all things that would have needed to have been figured out by the time, you get in front of a judge anyway. I guess where, money wise and financial wise, your client would need to be aware of, they're going to need to come up with a much larger retainer straight off the bat. Whereas previously you had months and months to get this detail down enough for your lawyer to go to court for you, say for your, originating family case conference back in the day. You need to now come up with the entire retainer straight off the bat so your lawyer can properly prepare these forms before you can even file. So, that's likely the difference budget-wise in terms of hours of preparation. Any questions at this point about this segment of the form before we move forward? Hearing none, let's talk about the next part of the application, which gets into a mini essay about the best interest of the child. Now, you're going to have to write about, I believe the order about parenting arrangements I'm applying for is in the children's best interest because. And now this portion is, you could really, for some, write a long essay about this. You're talking about the children's emotional health and well-being. You're talking about the children's views. You're talking about the children's relationship with parents, guardians, and other important people, the history of their care, the impact of any family violence. If you looked at even each of these, they could be like, you could write like a 3-page essay about why your proposal is in the children's best interest. Of course, you're expected to take, reasonable kind of view of this and, not go into crazy amount of detail. But bear in mind, I think there's a couple of things to think about. We'll get to the family management conference, where this part of the form will get looked at. Under the new rules, the family management conference is very different from a first appearance. Previously, at the first appearance, unless there was a notice of motion on the table, judges do not make orders that are not by consent, that are beyond administrative in nature. The new family management conferences, judges can make interim decisions. And the evidence that they're drawing from is this form. So, the danger of not putting in enough content in this form is that your client's going to be at risk of the judge making a decision without them fully having, the client fully having put out their narrative. So, if they're going to be high impact decisions being made, even on an interim basis at the appearance where they look at this form this form needs to be done well. You know, it's not something that you should just gloss over by having one line answer. I believe this is in the best interest of children because, you know, is the status quo. Let's say that's all you put. That is all the judge is going to be making the next stage decision on. That's not much to go on. So, you know, if you gave just a very cursory answer to this question, I think you're running a huge risk of a decision being made at the family case conference, the family management conference, that is not going to be in your client's favor because their evidence is not fully before the court. In fact, to me, the answer to this question looks very much like what you would put in an affidavit in Supreme Court. The flip side of that in terms of preparation, of course, like it's going to eat up a lot of your time to get too far down the rabbit hole with these questions. If you put in too much, you also run the risk of the judge not being able to fully review because, you know, you're now handing in a 30-page document. The judge is not going to have the ability to review that before the hearing. So while you want to be relatively succinct, you certainly need to hit on all 5 of these high points. Now, as support workers who are going through this process, as a tip, I would suggest that you go through relocation decisions that are available on CanLII. So CanLII is a source of legal database of previous case law, where judges have made decisions on just about anything, parenting time, relocation. The reason why I'd suggest that you just take a good read of some kind of provincial court relocation case or a Supreme Court relocation case is because they always have a segment in the decision that reviews these 5 topics. So you kind of read 1 or 2 and you will get a very strong sense of how to answer these questions and what you're really supposed to be saying based on your client's situation. So I would really suggest that if you want to study a little bit to better help your clients prepare to the answer to this question, that you take a look at those decisions about relocation. All you need to Google in the search terms would be BCPC, so British Columbia Provincial Court, and then the word relocation. And if you scroll through those decisions, you will find at least, you know, you'll find dozens and dozens of them that will go through how to answer this best interest question.
There are 2 questions there.
Yeah.
Excuse me. Yeah, there are 2 questions there. Can I ask you now or you want to
Oh, yeah, absolutely. I can answer those questions. Does legally allow for more hours to deal with these new forms? I think there are set hours overall based on each person's legal aid contract. You know, ministry files have their own time limit for how much time you get to spend on your family law case. Family law cases have preparation hours overall for general preparation. And so I think it's up to the lawyer to work with the client to set some expectations about how much time they're spending on these forms to get them to go, and for the client to really get a sense of how much time is left for everything else beyond this first stage. Now, Aaron's question is about what is the website to review case law, and it's called CanLII. So I just typed that into the chat, CANLII. Okay, let's check the time. We're 44 minutes in, perfect.
Yeah, thank you, Karen.
So we're on to the next schedule of the form. I've skipped ahead to the child support schedule instead of talking about changing agreements or court orders. In those ones, your clients will have to talk about what's the material change in circumstance that's occurred between the last thing that they signed and now. That will be the highlight, again, to support clients in determining that, what to say and what to put in. The trick would be to go through CanLII, Google material change in circumstances and see what kind of things qualify. And that will give your clients some inkling as to how to best present, their facts when they're seeking for a change from a previous order or a change from a previous agreement. Now, filling out the child support schedule. This is vastly expanded from the previous forms. It is long and it is quite arduous. So let's go through it. The current support arrangements are as follows. This is a simple question. Is anyone paying anything right now? Next, do you know the income of the other party and what do you believe it is? That's also relatively straightforward. This is usually what's the T4 line 150 type income opposing party has. 6 is perhaps the toughest question to answer. I know the following facts about the other party's employment, training, health, and ability to work. Now, from a lawyer perspective, when we read that, we know what they're getting at. They're answering what is known as an imputation of income question. This is where the other side is not, for whatever reason, fully, availing themselves of employment opportunities. This is where people are intentionally underemployed. And for some reason, either shortly before the separation, during the relationship, or shortly after the separation, they decide to quit their jobs, drastically reduce their income, or do something that may be nefarious or may be due to legitimate reasons for parenting or health reasons. But what number 6 is getting at is what's their income earning potential? Now, this is going to require your clients to really explore what is the other side doing and what's their status? Are they working their normal jobs? Are they not? And why? Their ability to work. There's a lot of things to go in there. In the spousal support section, there's actually a flip question that is identical to this, but that's about your client. We'll get to that shortly when we discuss the spousal support schedule. But here, if your client has any indication at all that the other side is going to be underemployed, question 6 needs a lot of information. Because again, this is where at the family management conference stage, you could ask the judge to impute an income and start a child support payment. So, you need to attach information about, hey, in the last 3 years, their tax return said this. They all of a sudden quit their job. It's not due to health reasons. They have a ticket in, welding or whatever. So there's a lot of information to get in there if you're looking to do an imputation of income claim. Next up, question 7. I'm applying for an order for ongoing support to be paid by the other side in the monthly amount set out in the child support guidelines for the following children, and then you list the children. So here, your client might need to have done some homework and looked into the federal child support guidelines about, what would be appropriate. That also goes to answer question 5, which is what their income likely should be. 10, you have to attach calculations. Select only one of the options below. I'm attaching calculations showing how much child support I believe should be paid according to the child support guidelines. So again, this is not original forms prior to 2021. You certainly did not need to attach calculations. This would be something that you would only likely prepare at a hearing stage. But like I said, because at the new, essentially first appearance, which is the family management conference, the judge can make substantive interim decisions about things like child support. Your calculations have to be in now. So calculations are, you can do it by a number of ways. There is a free website called My Support Calculator, which will generate based on the information you provided, like where the kids are living, how old are the parties, what are everybody's incomes, what percentage sharing they're at. They will generate something that you could print out to show the child support payable. 10 is a tricky one to answer when you don't know what the child support and parenting sharing is going to be. You're likely going to have to help your clients prepare a number of calculations, sort of like a plan A, a plan B, and a plan C, or maybe even more plans than that. And I'll explain why. Child support is dependent on the proportionate sharing of the children's time with each parent. If you hit more than 40% per person, you're in a shared parenting relationship, and your child support will likely be based on an offset of some kind if you're doing a strict guideline application. Otherwise, if you're one parent is less than the 40% mark, then you're in a primary situation and your strict guideline numbers, there's no variation. So if your client here have asked for primary, well, they're not guaranteed to get it. If the other side counters with, well, I want shared, and they get it, and the judge agrees with a shared arrangement, your child support is going to change. So first of all, that already immediately means your client needs to create two sets of calculations, a primary calculation based on the tables and a shared selection based on the tables. So that's already two sets of calculations. Now, if your client is uncertain about either their own income or the other side's income, now we're looking at like a myriad of various calculations. You might have to do some calculations based on your client at, say, $20,000 and the other side at $50,000, but maybe, with bonuses, their income should be $80,000, or you think they're under declaring in some ways. So now you have to do two sets of calculations, a 20 plus 50 and a 20 plus 80. Alternatively, your client might worry that there's currently at no income, but maybe they should be working. So what if like an income is imputed on them? So as you can see, answering paragraph 10 and attaching all those calculations, it could be quite the process just to run through all the scenarios that you want to present to the judge as a kind of a plan A, a plan B, and maybe a plan C in the alternative. There's also a risk of maybe giving too much information at this stage and giving away your position. I don't know if you're really seeking for an imputation of income at an $80,000 mark, that it would really be in your client's best interest to include, a $50,000 calculation just in case. That is really a strategic decision that your client needs to make, likely with the help of legal advice, trying to figure out, what really they should be presenting when they attach those calculations. Sometimes there is an undue hardship claim. If you do that, you'd have to answer paragraph 11. Now, heading into paragraph 12, special and extraordinary expenses. First of all, you could check a box if you're not applying for any. More than likely, your client will be applying for some. So it says in second box under paragraph 12, I'm applying for an order for special and extraordinary expenses under section 7. The following special and extraordinary expenses, net of tax credits, subsidies, etc., are included in my application. That is such a loaded question. Usually, you would present this information in a financial statement, which again is typically not due for some time, and it gives you some time to do that. Here, even in the initiating application, you need to fully prep your clients to answer what are all of their special and extraordinary expenses for their kids. So this is your client combing through every skating receipt, every swimming receipt, any hockey receipts, any of the equipment related to these things, team fees, competition fees, maybe there are travel costs, maybe there are ski passes, maybe there's like music lessons, perhaps there's preschool, daycare. If they have medical needs that are not covered by a health plan, orthodontics, all kinds of things. You need them all. So that tiny little box is probably not a good reflection of just how much detail you're putting in there. There's likely going to be an appendix with a lot of, calculations. And your client also needs to calculate what is like the net amount versus the gross amount, whether or not these things are recurring monthly or annually in terms of like team fees and signups and that kind of thing. Again, this is usually what would go into a financial statement. And in fact, it will be repeated when you do your financial statement. But this is another one of those things. You don't want to under-declare. If you don't declare it, you're not going to get it. So if your client forgets about, I don't know, swimming or skating, later on, they're going to have to add this information back in, and they're certainly not going to, have that information in front of the judge, so the judge could probably assess that expense. So if in terms of meeting with the client for the first time, trying to get them ready to fill out this form properly, remind your clients that they're going to need to collect receipts from the past 12 months, and have that information fully prepared for you so you could really help them fill out this portion of the form. So before we move off child support, are there any questions about how to complete this new schedule?
There are no questions so far in the chat.
Okay, so what if you make a mistake? Great question, Travis. This form can be amended, and you can certainly file an affidavit later on, or a financial statement you can correct by adding that new information in your financial statement. So that's how you would deal with mistakes. What you don't want, though, is fundamental inconsistencies that are more than just mistakes. And yes, a financial statement will need to be submitted as well if you're making a claim otherwise for special and extraordinary expenses. So what I mean by inconsistencies is mistakes are mistakes. So if your client honestly got it wrong, then of course you're going to correct it in your financial statement. You don't want your client to appear to be lying. It's basically what it comes down to. That's where the inconsistencies get dicey, and that's why you do need to do a good job on your first form. If there are now more than one typographical mistake, and it looks like your client is just like unbelievable because what they stated in their originating document is vastly different without explanation from their financial statement, we're going to have problems at trial. So that's where, it goes to your client's credibility. Like, where were you telling the truth? So you got to be pretty cognizant that you can't be like internally too inconsistent between what you're stating at your originating application and what you're following up with either at your testimony at trial or in your financial statement, because then it just raises questions of, well, is your client lying or confused? So as described, you're now looking at listing out all the annual amounts for each of these expenses. You got to fill out this chart per child in this form. Then to the question of whether or not a financial statement must be submitted, it actually does say you have to attach a financial statement at paragraph 13 if you are making an application for special and extraordinary expenses, or if any of the other options apply. So on to the final big schedule that requires a lot of thought, which is now Schedule 9. Schedule 9, spousal support. So it says that I believe I am entitled to spousal support for the following reasons. Then you got a whole bunch of boxes that you should check. Remember, check all that apply. Don't just check one. In all likelihood, actually, all four will apply. So you certainly don't want to undersell your client by missing one of the boxes. This is where in almost all circumstances, if you're asking for spousal support, probably all four boxes should be checked. Travis asks, is there ever a time where you put too much info in? I think there could be, like I said, you don't want to put in so much information as to overwhelm the judge so it's too confusing and you've got like 20 pages of attachments that, then it's not immediately apparent to the judge what they should be looking at. There's also a chance of wasting too much time. Say you're hiring someone privately or through legal aid to deal with these forms, putting in way too much could be just wasting too much time. And finally, you could put in too much info by offering too much information for the other side to critique you on. And that leads to, the danger of running into future inconsistencies. This is more relevant to the portion of the form that I'm going to chat to you later about protection orders. So we have to be very careful of the information that we put in there, putting in too much info versus too little. When we hit that part of the form, I'll specifically alert you to where you could run into problems putting in too much information. Now, onto this part of the form, remember I talked about you're going to have to state your information about your own income earning potential. That is the question to number 3. My current employment situation, training, health, and ability to work are as follows. Of course, your client is going to need to give a full answer there. But this is maybe where you could go wrong as well. Back to Travis's question, could you put in too much information? You don't want to overcommit your client at paragraph 3. You're stating what they're, if your client doesn't think she's going to be able to work full-time or he's going to be able to work full-time, don't put that into paragraph 3. Be very cognizant of what your client is signing up for in terms of the answering the full income earning potential question. So I do see another. Would the judge request extra information if needed, or would they say it's incomplete? Absolutely. The judge may require parties to hand in additional financial information or to put in a supporting disclosure and exchange that disclosure at a later date at a family management conference or at a family settlement conference. And Katie's totally right. The judge would then make that very clear at the court appearance. Oh, I think I skipped ahead too far. Okay. Next set of questions for the spousal support schedule. These will look very similar to the child support questions. Select one of the options below. Do you know the income of the other party? You've got to check box 2 if you're seeking an imputation of income. Okay. If you blankly say you don't know what the income of the other party is, it's going to be very difficult at your first appearance before the court to ask the judge to impute an income. If you're seeking an imputation, you've got to have checked off box number 2 and suggested an income so that the other party, when they make their reply, can fully answer your request. Number 5 is going to be identical to previously. If you've asked for child support, what their employment and training and health and ability to work is. And 6 is a hard one. Let's look at 6. I'm applying for an order for spousal support to be paid by the other side. And you've got 3 boxes. In the amount of blank to commence blank until some other time. Second box, in the lump sum of some amount of money. And third box, other. I can tell you that even family lawyers who have done it for years and years would have great hesitance answering question number 6. And this is because spousal support is amorphous. What if your client gets sick? What if her income decreases or increases? What if his income goes up or down? What if they need to go into a training program? Answering the question until could be a huge limiter to your client's case. Even the child support and spousal support advisory guidelines, if you ran through DivorceMate or the the My Support calculator on the spousal support question, it would give you a range. It would give you a low, mid, and high range for spousal support, and it would likely give you a minimum to a maximum range in duration. So be extremely careful answering the final part of until. You do not really want to put an end date if you don't have to. Like, because you don't have a crystal ball, like nobody knows if your recipient is going to have some health problems, 5 years down the road. And you certainly don't want to limit him or her to a specific answer. You might just put there unknown. Like, I would really be super, super cautious also answering the lump sum number. Even for lawyers, the lump sum, there's tax implications to that. There's like ability to pay, you have to look at the longevity of the person, maybe discount for life expectancy. Like, there's a gazillion factors that goes into calculating a lump sum. That would be, I would extremely be very, very hesitant answering 6B. I'll call it box B because it's the second box, or C. The other one is, and also answering the duration question. Just be very hesitant. You might select other by saying just pursuant to the spousal support advisory guidelines and leave it at that. You might even put in more information and maybe say it's an interim amount of something, of some quantity, maybe in the mid-range of the guidelines. And if your client's income is not totally set in stone and the other side's income is not set in stone, answering question 6 could really come back to haunt you. So be very, very careful answering this question. There's definitely some pitfalls in answering this wrong to begin with. And it's you might just want to stick with mid-range of guidelines and just leave that as the answer instead of really signing up for some number that you might not be happy with at trial. So before I move off of spousal support, any questions on this schedule? It is a very tricky schedule to complete when you really think about it. And let me know if you have any questions. So let's check the time. We're now at noon, or 12:07, so we have about 15 minutes left. Okay. So let's touch on some of the other portions of Form 3. So we're still on the first form, guys. I'm so sorry, but there's a lot to the first form.
I have a quick question. The time is 11:07.
Oh, right. Sorry. I'm in Mountain Standard Time, so here.
Yeah, that's what I thought.
But we still have the 15 minutes, so that's good. Okay. So we're on to the other side of the schedule. Like I said, there's a schedule to fill out if you're replacing or setting aside an existing agreement of order. If your client's filling those out, make sure he or she is going to go read some decisions about those things and look at what would amount to a material change in circumstances in order to seek some kind of a replacement or the cancellation or a variation of an existing claim, or get some independent legal advice on that question. There's also a portion of the form where you're applying to become a guardian. In certain circumstances, parties are not automatically guardians. Sometimes if you're parents to children and you were their parents before separation, you're automatically deemed a guardian in some of those circumstances. But other times you're not. Like, say you've never lived with the parent of your child, or you kind of separated before the birth, and you don't regularly care for them, you might not already be a guardian, or it might be a grandma or grandpa applying to be a guardian. Then you got to fill out the appointment of guardian schedule. If you're doing that, the form alerts you to the fact that you need to complete a guardianship affidavit as well as a criminal record check. There's like a ministry check component. So you've got to do those supporting forms if you're applying to become a guardian. So just be cognizant of that. Also, there's a requirement to declare the indigenous ancestries of the children, and be aware that your client will need to serve the Nisga'a government or the Treaty First Nation in order to start their guardianship application, and then the courts will have to consider those laws and customs in making its decision. Now we're finally on to the second form. So we're on to the reply forms. So of course, if one of your clients have been served with one of these applications, then you've got to do the reply. The reply is in Form 6. At that point, your client gets to do their own version of the application form in the form of a counter application, all the same schedules, all the same questions. Now they get to put in their side of the story. If you're the initiating party, once you get served with a counter, you get an opportunity to reply to say yes or no to some of those requests. So that completes the first segments of forms, which are Forms 6 and 8. Of note, if straight off the bat, everyone already agrees, they know what parenting arrangements or support arrangements they want, parties can submit their entirety of their consent in a consent order form, along with an application for a family law matter consent order in Form 17. So this is where no court is required, and you're looking to essentially have a judge not require an appearance and just hand in your consent. When the judge gets that consent, they can either make the order sought as is, they can maybe make it with some changes, they can write back and ask for additional information to be handed in, or they could say, no, this is a little too complicated, or they might have questions about your client's consent, such as there's something weird in there, not being paid according to guidelines, some type of relocation is suggested without, adequate parenting time to the other side. They might then set a court appearance and summon your clients to attend, or they can ask your client to give notice to the other side or some type of direction, or if it's flat out something that is totally outrageous that people have put into their consent order, the judge could reject it, providing some reasons about why they don't think it's acceptable. So those are the basic forms that are to start. Now, on to some of the other specialty application forms. So we already talked a lot about applications, but there's more. So there used to be a single-page form called the Notice of Motion. It was strangely used for all kinds of things. People were using it to seek interim parenting time. People were using it to get vacations. People were using it to get DNA tests or to settle orders, get disclosure. That form was very confusing, and it's honestly not really clear what you're supposed to use it for really back in the day. So now they've totally done away with it. It's gone. And instead, we're getting a whole host of other forms that are very interesting. We'll go over all of them in turn. So this is where you kind of already filed your first application, the one that we just spent an hour talking about. And you've got a whole bunch of other smaller things that you're asking for, not necessarily small, but like a bundle of specialty things that you're asking for. There's a specific form for something called a case management order that could be either with notice to the other side, meaning they know about it, the other side knows about it, or you could do it in some very distinct circumstances without notice. We'll get into that. There's a protection order application. There's something called a priority parenting matter application. There's a prohibition of relocation application. There is also an application for just enforcing things. Those are like all the applications. And if you've got one of those and you're making a response, there's a written response application form, which is in Form 19. So usually what will happen is someone will file one of the top forms. The written response will be done up, and then there's a court appearance on the matter, and there's some kind of hearing. It could be a hearing or a trial. So essentially, the judge decides at that point. So let's get into the first one, the case management order, Form 10. So the way to think about this form is that you're using this form for some kind of administrative order. And what is an administrative order? This is where it's a process type thing and not a substantive type thing. Perhaps we should dial back and talk about what's a substantive type thing. Substantive type thing is where you want parenting arrangements, you want child support, you want spousal support. Those are substantive orders based on evidence and, something to do with kids, something to do with money, that kind of thing. Case management process type orders, this is where you want, to appoint a lawyer for a child. You want to correct a name on, the style of cause. And I'll go through them. So you could ask for access to a file, management to a file. You might want to transfer a file to another registry because everybody has moved. You might need to correct the date of birth because someone listed it wrong one time. You might be seeking some type of financial or document disclosure. You might want to be getting a DNA test. You need to adjourn a court appearance because, are you now booked in for surgery, can't make it. You might want to settle terms of an order. You might want to get a conduct order, a views of the child report, a section 211 report. You might want to set aside a subpoena because your witness can't make it. Or you might want to cancel an order that was made ex parte, which means it was in the absence of a party. So the case management form, application form, basically has a checkbox for each of these things. And depending on what you're doing, like, oh, my name was spelled wrong on the order, then you would check off correct file document and list out what exactly you want done. And then there would be a court appearance set to deal with that one thing. Or I want a DNA test, for this child, that would be something you would check off on the form. And then there's a specific mini hearing about, should you get a DNA test and who's going to pay for it and that type of thing. So these are case management orders. Now, these orders can be made at any time. It's usually generally to manage a case in some way, to prepare for the next steps. Now, usually they're made with notice to the other party. So if you're trying to set aside the trial date, obviously the other side's going to need to know about this, right? And to explain, whether or not they agree with it, or maybe they don't. Maybe their witnesses can only do it at that day, so they shouldn't move it, or maybe they've waited long enough and the thing is urgent, so they oppose. So that's why generally these case management orders are made with notice to the other side. Now, obviously, if the other side agrees, you can do it by consent and choose to have a judge review it without needing to everyone take a day off work and go to court. And then usually by giving notice, you're serving the other side with an application, a copy of that application, and all of your supporting documents which have gone in with it. Say you have surgery scheduled for the trial date, you're seeking an adjournment, you might have a doctor's note saying, yes, your surgery is scheduled for that day, so you can't go. Now, in rare situations, you can use Form 11, where you don't want to give notice to the other side, or somehow it doesn't make sense. For example, if you're looking for a substitutional service, so obviously you couldn't find the other side in the first place, and you're looking to avoid needing to personally serve them because you don't know where they are, and the only way you can contact them is through, Facebook Messenger or email or whatever, it clearly wouldn't make sense in that instance to serve them with the application because you don't know where they are. So if you're looking to modify service, alt service, you're waiving some kind of requirement, under very rare circumstances like the ones listed, you can do this without the other side knowing, sometimes for practical reasons, like you don't know where they are. In that case, you would fill out Form 11. The judge will then, decide whether or not it's valid or not valid and whether or not to grant the substitutional service order. Any questions so far about case management orders before we move on to the next big topic, which are protection orders?
Thank you, Karen. There are no questions at this time.
Okay. Protection order forms. This is Form 12. Let's talk a little bit about what these things are, first of all. Protection orders are orders that protects one family member from another family member if there's some risk of family violence. The highlight here is risk. There doesn't need to already have been family violence. Sometimes there is, but it's applicable if there's a risk of family violence. So in putting together this application form, you will be seeking some type of condition on that other family member. You know, no contact, don't come to my work, don't come to my house, some type of communication requirement, maybe no communication, maybe communication just about the kids. It is a very serious criminal offense to disobey or breach any conditions in a protection order. You'll be criminally prosecuted for such breaches. Now, the orders don't last forever. Sometimes they're for a specific duration, like if the judge should say, yep, it's an order valid for 3 months or 6 months or whatever. If there's no specific end date on the face of the order, they automatically expire after a year. So bear this in mind. They're not forever. Your client will have to apply for a renewal, like not at the 1 year mark, like sometime, like month number 9, if your client wants to have this renewed, you should be seeking a renewal of the protection order. So parties can apply for themselves and the child, or they can apply for on behalf of another adult. You know, this might happen, for example, if there's a vulnerable adult in the family, you know, an elderly person or someone who's otherwise not able to bring the application on their own. Protection orders. As a support worker, helping someone put one of these together, there is an aspect of the box where you check off, are you applying with or without notice? Again, if you're applying with notice, it means right away, before going to court, the other side is going to be served with a copy of this application and read in great detail what your client's problem with them is and what your client's looking for. Obviously, this in many situations would exacerbate the situation, create more conflict, and perhaps create a dangerous situation for your client, especially if the other side is a dangerous person to begin with and you're seeking a protection order. So as I said, normally you do need to give notice to the other party by serving everything to them because it's fair for them to be able to make a fair answer in defense, right? Like they you know, the courts, these are very serious orders. If at all possible, the court wants to hear from both of you to see like what everybody says, test the veracity of these claims, etc. So, but under very specific circumstances, it can be made without notice. For example, if there is imminent harm or danger coming to your client, or providing some type of notice in advance would probably create the risk of real danger or violence or some type of serious consequence. Like, you know, if the other side knew, they'd probably come and, you know, do some harm to you right away. Now, getting a without notice application is actually pretty common in protection order cases because if it's serious enough for your client to be seeking one, there is probably some risk of danger of the other side, you know, knowing right away and the order is not in place. So oftentimes the court will allow the without notice thing to go ahead, but make it a very short protection order in duration and say, fine, you'll get the order, but then you need to serve the order to the other side. The other side will know about it, and everybody then will come back in 2 weeks to have a full opportunity to argue about it to see if a new order should be renewed for like the next year. So that's kind of how typically I've seen it dealt with in court where you ask for it without notice, they'll know. I mean, the other side obviously has to know that there's a protection order out on them. They will know, they'll find out, they'll then have the opportunity to like answer that protection order, but the order is already in place for a kind of a limited time. So we do have a couple questions here. If a protection order is granted in family court, is it police enforceable? All protection orders are police enforceable. They have the full force and effect and are enforceable under the criminal code. And like I say, a breach is a criminal code offense. Travis's question, is it the abuse for the children or the parent? The family violence could be to any like person in the household. Even witnessing family violence, in some situations, the court have thought of it as a protection concern and a type of violence kind of vicariously for the children. So yeah, all of this is kind of part of the protection order and kind of the detail that you can get in when you explain why you want this protection order. So let's take a look at the protection order application itself in some detail. Schedule 1 affidavit must be signed with a commissioner for taking affidavits. You will note with the other applications, there's no requirement that it be sworn evidence. When you put things into, obviously you need to be telling the truth, okay? Your clients cannot lie on a court form. But there's a specific requirement because the protection order application is so, it's an infringement on the other person's, liberty and persons. These are very serious allegations. Your client must be willing to swear or make an affirmation in front of a commissioner that everything they put in there is true. So the form at the bottom of the form, you need to bring your client, or your client needs to go with the form to either a lawyer, a notary, or back to the registry to have their evidence sworn in by a commissioner. So understanding that, there is, and I think Travis asked you a question about, well, what if I made a mistake? They better not be making a mistake on this form because it's so serious and it's sworn evidence. It so often when there's a protection order request, and we'll touch on this on the next slide as well, there might be a matching criminal file. Your client might need to testify in criminal court about whatever incident occurred that led to both the request for a protection order and the criminal situation that's going to trial. And your client, you need to be so cautious in supporting your clients through this. And it's a lot of pressure, but they can't give competing evidence or inconsistent evidence. And where this can go wrong is usually the evidence is collected at many stages if there was an incident. The police would have attended at the house. They would have given it a verbal, statement to the police back on day 0, right? Like when the police showed up, they would have said, oh, this is what's happening. This is why I called the cops. So there's like the 911 call and what they said there. There's like when the police arrived, what they said there. If they then get interviewed by the police back at the police station in the days to come, there's that statement there. And now this is like the 4th potential statement that they're making in the eyes of the law. And even if I asked like any regular person to retell a story about something that happened at lunch, 3 days ago, every retelling at the end of the day is going to be, a bit different because, your memory changes, the way you present something change. Be so cautious when, you don't want to prejudice your clients. You don't want to, prejudice your client's case. You don't want to make it so that they've provided an inconsistent evidence, at the criminal hearing and be found not credible. So this is where you walk the fine line between being vague and putting in too many details, which is somehow maybe inconsistent with what they told the police in the first place. So it's kind of a very, you have to be, if as part of this protection order application, your client is stating in quotation, at that point, he, grabbed my hair and said, "I'm going to kill you." And those are the exact words, and your client is committing that statement in the affidavit. That better be also what they said to the police. Otherwise, it's better to not put things in hard quotations to say that, the statement, then you got to be careful saying in your protection order, then he threatened to kill me, and not put things in specific wording, which then your client might be cross-examined on, later on, because that wasn't exactly, what was said. So just be super duper careful in filling out this form, given, the circumstances. Now, as part of the form, of course, you can ask at paragraph 3 here, I don't want the other side to go to my house, my place of employment, etc. You want specific kind of communication clauses you can put there. You have concerns about, guns and explosives and firearms. You can put your explanation of your concerns there. You want as much information in here as your client really, if they have these concerns, obviously it's important for them to be granted this protection order. Again, this is where you want to be as factual as possible without somehow creating inconsistent statements between what they told the police and what they told, the investigating officers at the station. And this is where also paragraph 17 and 16, where you talk about the mental health concerns of the other party. Paragraph 17, where you describe any of those situations that are create the risk of family violence. Honestly, this is such a tough form to do. And, it's about coming to really setting aside quite a bit of time to work with your clients on this form, understanding that answering 17 and 16 for most people would be extremely traumatic. It's 100% a trigger. I mean, if you just read it, the things that they have asked you to describe, it's really tough having gone through. If you have some of those things to talk about it, you need to give your clients lots of space, and maybe, if it's beyond your training and experience, to work with clients about filling out paragraph 17. You might need to involve your Stop the Violence counselor or someone else who, could act as a support with that training and experience to support someone answering question 17, because it's such a tough thing to write about and to share, not only with the strangers in the room, but also with the court, and understanding that at some point, the perpetrator of these things will get a copy of this form. That's, writing 16 and 17 is very, very difficult. So, just have to be super mindful of that. Travis has a question. Is there a time limit on completing all these forms? Like when you pick them up, you have a week to complete? No, the forms are always available. I guess the only time limit you run up against is unless you filed it, you're not getting it. So, the longer you delay your child support application and spend the most time, putting it all together, the longer the delay to get to court to, get it done. Or the protection order is probably more pressing, because if there's imminent danger to your client, which this is why you're filing the protection order in the first place, you're not getting your protection order until you've, completed your materials and handed them in. So the time limit that you're running up against is just whether or not the delay prejudices your client. The other time limit is perhaps if you were the responding party and you were the one doing the counter to the first application. Of course, then you're court bound by the days you've been served to get that material in on your counter application. So paragraph 25 is very much akin to 16 and 17. You have to describe the incidents of family violence that's already happened, any trauma, attach police reports and photos and doctor's notes. This is a big, big, big process. You're committing essentially your witness list on paragraph 25. You can see like the who witnessed it, who was involved. There is a lot to completing this portion. Again, be very mindful of whether or not you're raising inconsistencies between your client's present evidence and the evidence they gave the police. You then would have to attach all of these things as exhibits. So, getting doctor's notes and police reports would be the difficult one to find because that requires a special order for disclosure before the police will release that document to you. And they honestly might not if it's an ongoing investigation. So some of these things are going to be difficult to find and get your hands on in order to have them handed in. Maybe the best you can do is the police report file number and which officer was involved on that day if it was a recent incident. Otherwise, you'd have to seek a specific police disclosure order, which you have to get the case management form to do and serve that on the RCMP, big process, So do your best on paragraph 25. And again, recognize that this is going to be extremely hard for someone who's already lived it to then have to, retell it. Okay, protection order forms done. Next up, applications about priority parenting matter, form 15. So priority parenting matters are very specific. They're usually decisions about the children where not all our guardians are in agreement. And if there's some specific rush to know the answer to that question, and you want to separately decide this beyond the usual parenting schedule, etc., but something must be done quickly for some specific reason. So let's take a look at when those apply. Oh, we have a second question about the protection orders. Would a protection order form be court ordered? Not sure, Travis, specifically what your question means, but certainly I've seen judges suggest to parties that they might wish to make a protection order application. If even the judge recognizes there's family violence, they'd be like, why aren't you filing a protection order request? Okay, so back to priority parenting matters. You can make sometimes these with either short notice or no notice at all. If again, there's some real risk of serious consequences if the other party is given notice. Here, it would be more of like an example would be a flight risk. The other side has threatened to leave the jurisdiction with, your kids. And obviously, if you told them about it, they won't wait to leave. They leave now. So where there's a real risk of some type of serious consequence if the other party is given notice, this is where you might want to do the without notice option for a priority parenting matter. Here, though, if you want to do it without notice, you must also complete Form 11, where you seek the case management order without notice. So, what are the usual topics covered by Form 15? Health treatments if delay will result in risk to health. Passports, where you're applying for a passport, they have to go somewhere, school trip, something like right away, something like that, and the other person is refusing to sign your passport application. If the kids are traveling or participating in some activity and that it's the other parent saying, no, you can't go to soccer camp and camp starting, in 4 days, that type of thing. If there's never been a court order and the other side's trying to move with the child, this is, part of that earlier example where someone is trying to take the child and leave the jurisdiction in some form. And obviously it's going to have an impact on the child's relationship with the parent that doesn't move. Some type of wrongful removal of a child. This is like the international child abduction type situation, or abducting them to Alberta without consent of the one parent, that type of thing. Some types of interjurisdictional issues and certain kinds of like emergency ministry matters, either talking about doing an emergency family application that's going to prevent a removal of the child, or to encourage the return of a child. And those typically you'll know about because the ministry is initiating it. So these are the very, very limited circumstances where you can use Form 15. It is not about interim child support. It is not about interim spousal support. These are like very serious, time-limited parenting issues mostly. So that concludes all of the major application forms. There are still tons that we won't have time to cover today, but we've hit on the highlights of the most commonly used ones that you're most likely to encounter. And looking at the time, we've only about 20 minutes left. So I'd like to leave some time for question and answers, which means we must now go to talk about the 3 major new court appearances pursuant to the new rules. Update to court appearances. These are the newest things, family management conferences. By now, some of your clients may have already attended some of these either in person or via MS Teams, virtually, essentially on kind of Zoom. And these totally replaced the original first appearances where it was very confusing and nobody knows what to expect at them. And there's like 40 other people sitting at the court registry and you're waiting all day and not sure what's going to happen. These are now specifically arranged. Time is set aside for your client. There's less people at those remand dates, and the judge would have had the opportunity to at least go through your application and any counters and replies. And this is the typical first step, is your clients attend the family management conference. Now, the registry will help schedule it. Everybody will typically get notices of these. At a family management conference, the judge can assist the parties to identify some of the issues that are about to be hopefully resolved. They can explore some options to resolve those issues, such as, alternate dispute resolution methods, etc. They can make case management orders or directions to make sure the case is then ready for the next step. So let's say the next step is everybody's going to go to a settlement conference. Then the judge might direct, hey, person B, you haven't filed your financial statement yet. You got to file your financial statement, within 30 days. So that's the type of direction dealing with process that can help the parties, move the file along. Now, the biggest change is this next paragraph. Make interim, which are temporary orders about family law matters without consent. This has not typically been the case in years prior. This is now specifically something a judge can do at family management conference. Order interim child support, order interim parenting plans, order interim things about spousal support. And this is one of the key reasons why your client needs to be aware of 2 things. 1, they must have done their initiating forms with enough detail if they're requesting stuff or defending against things. 2, they must be prepared to kind of advocate for themselves at this family management conference if they don't have a lawyer. It's not totally going to be administrative. It used to be that by and large, first appearances are entirely administrative. Oh, okay, group 2, you guys next step, just file your financial statement, go to your, case conference would have been, a normal event back in the day prior to May. Now, you attend a family management conference, essentially anything can happen interim-wise. The judge could make factual findings that leads to a real parenting arrangement being set in stone temporarily, I suppose, until the next time you get in court. But when you really think about that, the next time you get in court might be like months from now. So whatever interim parenting arrangement isn't going to last for 4 days. It's going to last for months. You know, the support that's in place will last for months until, say, the next settlement conference or a hearing. So be very, very careful in preparing your clients. If they've gone to court before at a first appearance and they thought that was how it's going to go, this is not how it's going to go. Like, it could be, lots of things could happen at these, like, and they need to be prepared to make submissions on the fly, to answer the judge's questions, to defend their position. Lots of robust things could happen at these that are not by consent. Having said that, of course, the parties, if they do consent to things, can make consent orders at family management conferences. And if the other side just squarely doesn't show up, you could ask for an order in the absence of the other party. If Katie had a question about whether or not you would go straight from filing to a family management conference, you could ask for the shortening of time if there is a, like the other forms that we talked about, if there was like a priority matter, or you're looking to shorten the time or do it without notice, you'd have to do one of those forms and see if those get approved. But here, the registry essentially tries to schedule the next available family management conference once the usual reply timelines have expired. So you get a date by working with the registry and the judicial case manager to find kind of the next available family management conference date. And I see there was one other question. Steve had a question: would using Supreme Court to address child support matter be usually quicker than provincial court process? Great question. Maybe is my answer. And the maybe is because there's a mandatory requirement in Supreme Court for a judicial case conference. And in order to get out of that, you'd have to make a requisition and do a specific waiver of that mandatory process. Now, obviously, if you're not successful, you're probably not faster. If you were successful, you'd probably land about the same timeline, I would say, between getting a date for a family management conference and getting a Supreme Court Chambers Day for child support. I'd say kind of roughly maybe about the same. Having said that, I suppose it would depend registry to registry. You know, some registries have chambers sitting every day. In Cranbrook, there's an assize every month, you know, approximately. So in Cranbrook, it probably not be faster in some instances. It also depends on, like, is the next Chambers Day a week from now, or is it like a month from now? So it's uncertain for sure. I think you could get into Supreme Court faster sometimes, perhaps, if you complete the full waiver process, but maybe not. Timeline for reply is generally still 30 days after service, but it states on the reply form and also on the application form for that specific application how quickly you have to reply. So on to the second to last topic, which is the family settlement conferences. These are previously known as family case conferences. Everybody is really familiar with them. They are essentially some type of private conference mediation between the judge, the parties, and if they have counsel, with counsel. The judge will explore the dispute, try to figure out some common ground between the parties, and talk about the needs of the children, talk about some potential parenting arrangements. The judge will do their best to help parties reach an agreement. Everybody will have a chance to talk about what's important to them and what their problem with the situation is. And the judge could also provide some comments about the strengths and weaknesses of each party's case, and provide their feedback on kind of how things are going. Judges could also make conduct orders and process orders, which move things along, like file your financial statement, or talk about the witness list and things like that, to, if they are not going to settle, to help guide them to trial. The final thing is a trial preparation conference, which is new. These are short court hearings with a judge to discuss how the trial will proceed, how many witnesses everybody's calling, the length of the trial, and the judge will help explore any additional steps that may need to be taken, like exchange of exhibits, exchange of what we call will say statements for witnesses, such as like, okay, you've listed, Amy Jones as your witness, this person doesn't know who Amy Jones is. What's that witness about? Are they a counselor? Are they a babysitter? So those are called will say statements, and a judge could ask you to exchange those ahead of the trial. And of course, as usual, what hasn't changed is, of course, after trial preparation conference, you're going to have your final hearing/trial to deal with all of the outstanding matters. Of course, there's also hearings about interim things like the priority parenting matters. Those will go to a quick hearing without deciding on all the other issues. So those are all the same as before, regular hearings and regular trials. And that leads to the end of the presentation. I've left about 10 minutes for questions in case anyone else have questions about any of the things that we've covered today. I know it's been a long 2 hours, lots of information. Believe it or not, there are actually tons of little things about the rules, about expectations around service, etc. Things that have changed that are not covered today that you'd have to refer to the rules about. Oh, and we have a big question from Aaron. If one party files family matters in Supreme Court, is there a form the other party can file to get the case heard in provincial? Good question. So if a file has already been filed in Supreme, you got to answer in Supreme. You could, at that point, ask the Supreme Court judge to move the file to provincial and make your submissions there. But you can't just start another action in provincial unless you've successfully talked to the Supreme Court judge, decided there that the file be downgraded and transferred to provincial court. You can't just start alternatively like your own action somewhere else. You have to answer the Supreme Court action if party A has already filed in Supreme on the same matters, same parties, everything. Supreme Court seems to be much more expensive, and most legal aid lawyers in our area do not take on Supreme Court cases. Yeah, Supreme Court is expensive. For sure, because Supreme Court, you're dealing with like asset division and all that as well, frequently, that it's much more complex, a lot more is dependent on it. Sometimes I've seen that where parties have settled on all of their asset division, if the only matter left is the relocation of a child, for example, that parties can jointly request for the file to be transferred to provincial court for all purposes, just to deal with the remaining parenting matters, so it's cheaper. Or one party could make that suggestion. Although that's more atypical, that, if both parties aren't in agreement, the file will likely probably stay in Supreme. And Supreme also have other consequences, like cost consequences if you lost, which are not part of the usual provincial court regime, which, many people have to be mindful of, that if they took an unreasonable or a non-winning position, that they could get a cost award in Supreme Court. So I hope that answers that question. Oh, thank you. One person said it was a very informative 2 hours. I hope it was. I mean, we squeezed in a lot of information. And hopefully that was a practical explanation of how to help your clients in supporting them with the new form and the new process that is part of provincial court in BC. And
no, thank you, Karen. It was very, very informative, and you explained it very well. Me and Alessia and Sarah, we were talking on the chat that you should be a teacher. It was a very well explained. Every section was so laid out, so good. Very well done. Thank you.
Thank you, everyone.
Yeah. Lots of thank yous are coming to you, Karen, on the chat as well. So it was a brilliant presentation. Thank you for sharing all this, these new rules, wealth of knowledge, while our others are in trial, and you have done an amazing job putting them together.